Yes, please.
May it please the Court, my name is Marie Maddox on behalf of the appellant Robert Crouch. And this case also comes before the Court on the grant of a directed verdict in favor of the Public Service Commission. The trial court ruled, first, that Mr. Crouch's verbal complaints of his chain of command did not satisfy the requirements of the Public Whistleblowers Act. Second, that Mr. Crouch failed to meet the requirements of the Whistleblowers Act because his complaints about Mr. Willis, his supervisor, were not in writing. And third, that there was no direct evidence that the complaint that Crouch made of his chain of command ever actually made it to the PSC Inspector General John Grayson. The third issue is no longer an issue, as the Public Service Commission has conceded that that was in fact error by the trial judge on that one point. The issue here, and I need to go through the facts a little bit about what happened. Mr. Crouch, in the 2001 time period, noticed that his supervisor, Marshall Willis, was taking action against a company that was regulated by the PSC, and that he did not believe that the action was justified, that the penalty was justified against this company. Mr. Willis, at the same time, had taken what was normally an engineering function, the preparation of certain documents and quality of service documents, and had reassigned those to an accountant rather than it being an engineering function. And the PSC regulations had always put that as an engineering function rather than an accounting function. So Mr. Willis had essentially made his recommendation, the recommendation he'd given to the accountant, the primary recommendation, and then had put the engineering recommendation in violation of the SOPs within the PSC, had put that as the secondary recommendation. What Mr. Crouch felt after his conversations with a coworker who had said that he had heard Mr. Willis say, "I'm going to get them," or something along those lines, going to get him, referring to Sunrise, the utility. He had taken that information, knew that, and he also had seen the penalty that he felt was not justified based upon their investigation, the engineers' investigations. And he went to his supervisors in March of 2001, the executive directors, or the division directors within the PSC, and reported to both of them that Marshall Willis was using personal bias against the company.
Didn't that report to his supervisors have to be in writing?
Yes, sir, it did, but we're kind of going on a little bit of a different twist in terms of, if you're looking at subsection 7, to what employees who file any written complaint to their supervisory officials, yes. But if you go back to subsection 6 and you look at to whom the information must be disclosed, the information must be disclosed to someone who has the ability to remedy the problem. If you start first with subsection 6 and say, okay, who did he go to? Okay, he went first to his to the division director, to the assistant division director, then to the division director. Then he goes up the chain of command in July of 2001 and goes to the executive director of the Public Service Commission, someone who, without a doubt, had the authority to remedy the violation that he was reporting. So he.
Well, you're not saying that if he had simply gone to his agency supervisory officials and had made an oral complaint to them, that would have sufficed?
No, sir. The plain reading of the statute would say that that would not suffice. But if you take who he went to, okay, and the fact that Mr. Grayson testified during trial that these upper-level supervisors had come to him and told them that Mr. Crouch had made a report. And that's what we do not have a direct report, admittedly, to the Inspector General's office, but what we have is a dotted line report that went to the Inspector General's office. And Mr. Grayson testified during trial, and it's been cited in our brief about what Mr. Grayson had testified before trial and then during trial. And he said that there had been actually 2 investigations that were done. The first investigation was while Mr. Crouch was still employed, and then he was fired shortly thereafter. Then there was another investigation done after Mr. Crouch was fired. So you have a dotted line rather than a direct line. And
so you're suggesting that that would satisfy the requirement to submit a complaint to the employee designated as agency inspector general?
Yes, sir. It does not require that subsection that subsection, if you read together where it starts with legal affairs or employees who file any written complaint to their supervisory officials or employees who submit a complaint to the Chief Inspector General or the Inspector General for the agency, the defendant in this case has taken the position that that's only, that you've got to have it in writing. It's got to be in writing. But the statute plainly includes a written requirement to the supervisory officials, but it does not require a written component. There's no written component when you're submitting it to the Inspector General.
I'm having difficulty understanding how either side in this litigation could think this is clear. Because it's far from clear to me, but maybe
Yes,
if I read it a few more times. I guess a question that I had was, now it's clear that Mr. Grayson, who I think was the Inspector General, the
Yes, sir.
information finally got to him.
Yes, sir.
Was there any testimony or other evidence? Now, I think Mr. Crouch went to Devlin and Tudor and Talbot.
Yes, sir.
And one or two or all three got this information to Grayson, who's Inspector General.
Yes, sir.
Was there any testimony indicating that their intention after their conversation with Mr. Crouch, and was it communicated to Mr. Crouch that they were going to the Inspector General, or did Mr. Crouch ask them to report it to the Inspector General?
What he testified to during trial was that it was his intention to initiate an investigation and to stop Marshall Willis.
Well, I understand that, but I just wonder if Mr. Grayson's name or position was invoked in connection with any of the communications between Mr. Crouch and these three gentlemen to whom he made the reports.
No, sir. I can tell you that his testimony at trial was this. His intention in reporting Willis's actions involving Keene Sunrise was to initiate some type of investigation into Willis's action, and that's the transcript, volume 2, page 187. And that's what he testified to, that he was reporting to them so that there could be some kind of an investigation into Willis's actions. They then went to Grayson. Grayson then did this investigation according to his pretrial testimony. At trial, it was somewhat different. But he did testify prior to trial that he had initiated an investigation, and it was shortly thereafter that Mr. Crouch was fired.
So there was no representation made to Mr. Crouch from either Devlin, Tudor, or anyone else that they would relay the information given them by Crouch to Mr. Grayson?
No, sir, I cannot make that representation. I can only...
Now, I tend to agree with you insofar as the necessity of a written complaint to Mr. Grayson. However, it seems to me that the statute is rather clear on its face, arguably clear, let me put it that way, that employees who submit a complaint to the Chief Inspector General, it seems to me that this submission reasonably implies a direct submission of a complaint, not through an intermediary, not through someone whom you assume may, within the chain of command, relay this information. I'm just looking at the dictionary definition of the term submit, which is defined, among other things, as to present or propose to another for review, consideration, or decision. Now, it seems to me that that definition reasonably implies that there be a direct submission of this information to the Chief Inspector General.
Your Honor, I don't think the law is clear, and I would agree that we have struggled with that term, and I would like to reserve the rest of my time but respond very briefly to that, the law is not clear as to whether it has to be a direct submission. But looking at the facts of this case, if the information did, in fact, you used the word may get to the Inspector General, but here it did get to the Inspector General. And if it got to the Inspector General and the reason that he was fired was because of that relay of information, then Irvin and the breadth that Irvin has given to the to 112.3187 should certainly provide protections to him if it did, in fact, get there. Not the may, but it did, in fact, get relayed to the Inspector General. And I would like to reserve the rest of my time.
May it please the Court, my name is Jason Taylor and I represent the Florida Public Service Commission. As Your Honors have heard, the undisputed facts in this case are that, one, there was no writing prior to Mr. Crouch being asked to resign. And the second undisputed fact is that there was no direct communication by Mr. Crouch to the Inspector General prior to the request for him to resign. These facts are clear, they're undisputed, and based upon the language that is also plain in the statute, the directed verdict by Judge Ferris should be affirmed. The Public Service Commission does concede the argument that Judge Ferris's ruling as to the issue of the Inspector General's testimony is incorrect. However, that does not invalidate the directed verdict, and it should be affirmed. The requirements of the statute, as Your Honors have pointed out, and what we're looking at under subsection 7 is only the last subpart of subsection 7. And the Public Service, we're of the opinion that there is a writing requirement because there is no separation, no semicolon like the other subparts of that section that separates out the written requirement from the complaint submitted to the Chief Inspector General, Agency Inspector General, or the FCHR. However, what you also have to have in that subsection and in that subpart of that subsection is that the language is clear that either you have the writing requirement, which Mr. Crouch undisputedly does not have at all prior to the request for his resignation, or you have a complaint that is submitted to one of the three people identified. And Judge Irvin, I think you hit the nail on the head when you said that this is an action by the employee claiming the protection of the statute. Without the direct submission of the person to the Inspector General or the Chief Inspector General or the SCHR, you have at best a dotted line. And that dotted line is not in line with the rest of the subparts of subsection 7. In each of the other subparts of subsection 7, what you have is a documentation. You either have the written and signed complaint, the request to participate, or the refusal to participate, or you have the documentation of the whistleblower's hotline. What you have as far as that last subpart of subsection 7 is you have the written complaint, which is not here, and we also do not have the direct submission by Robert Crouch to the Inspector General or the other people identified in the statute. What appellant is claiming is that it's enough to go to the supervisor and have the supervisory official then go to the agency inspector general. However, the plain language of the statute says that if you're going to go to the supervisor, it requires the written complaint. And that is just the other clause in that last part of subsection 7. The other issue I'd like to address as far as the part of the
Let me ask you your position on the statute. Is it your position on the statute that if there were a direct submission to the agency inspector general, would that have to be in writing or no?
Your Honor, we believe that without a division between those subparts, there would have to be a written requirement a written submission to the agency inspector general or the chief inspector general. However, we don't even have to reach that point because we do not have the direct submission by Mr. Crouch to any of the people identified in the statute. It was classified as a dotted line. And because of that, you're missing information. You don't have a direct line. It is not a direct submission as required by the plain language of the statute. The reason why why we believe there is a requirement there be a direct submission is because of the obligation of the person who receives that particular information. If you have a written complaint to the supervisor, you have that documentation. However, without a direct submission, you don't have the information that is needed for the agency inspector general under 112-3189 to make the investigation and conduct it how he is required to under the statute. And between the two sections, subsection 7 and subsection 6, this is another issue that I believe the court should interpret to require a certain class of individuals. Under subsection 6, what you have is not the people or the entities or federal government agent or the agency or federal government entity with the ability to do this, but you have the authority. That was the language used by the statute. And each of the individuals or the entities referenced in subsection 6 of the statute is given statutory authority by the legislature to conduct an investigation. With the agency inspector general and the chief inspector general, it's found under 112-3189. With the FCHR, it's found under 70.06. So you have not only the ability, but you have the language used in the statutory authority to receive this information, make an investigation, and then do something, an obligation also under the statute to do this. The language requiring either a written complaint or a direct submission, because the language is employees who submit a complaint to one of the three people identified in the statute, is plain. And the case cited by appellant in his brief, Martin County versus Edenfield, has specific language that describes the court's duty when you have plain language under the statute. And the case states Florida law is well settled that where there is an ambiguity, the plain language of the statute has to prevail. We don't have ambiguity in this section of the statute. What you have is two requirements, one, either a written complaint or the submission. And without either, and it's clear that the facts are undisputed that in each of these cases you don't have either by Mr. Crouch, that the language is clear and therefore the directed verdict should be affirmed.
Your stronger argument is that there was no submission, though. I think you'd agree with that, wouldn't you?
Your Honor, I believe that the stronger of the two arguments is, are you saying...
The reason I find this so confusing is that after the semicolon, there's the disjunctive or, and then when you come to the next disjunctive, there's a new subject. I mean, we have, or employees who file any written complaint to their supervisory officials, or, and of course, if the intent was to include the written requirement, there would be no reason to have a new subject. But what it says is, or employees who submit a complaint to the Chief Inspector General or to the employee designated by the Inspector General. I mean, I'm just really at a loss to know why, if they intended the written requirement, there would be a new subject and a new term for the document to be submitted after the disjunctive, if it encompassed, after the second disjunctive, the writing requirement.
Without a repetition of the word written.
Right.
If they wanted to say it required a written contract, they've said it many times in here, and even in the same phrase, and they could have said that.
Yes, sir.
They could have certainly worded this in a better way, using your plain language approach, to plainly have said this required a written contract, but they didn't do that.
And to go back, I think, to the beginning of the question, I think, yes, Your Honor, the stronger argument is that there is no submission by Mr. Crouch. The argument that it be in writing is based upon the way the statute is divided, which may represent an ambiguity between those two subparts. However, the facts are clear that what we do not have is we don't have him meeting. It's obvious that he does not meet the writing requirement. And it is also undisputed that there's no submission based on the plain language of the statute being requiring a direct submission, that it's employees who submit to these three people. And there is no direct submission. At best, appellant has conceded that this is a dotted line and lacks the information necessary to establish the documentation that is required by or is demonstrated by the other subparts of subsection 7. And without this ambiguity, without there being an ambiguity in those two requirements, arguably there is an ambiguity between the two, the plain language should prevail and the directed verdict should be affirmed.
Thank you.
Mr. Crouch reported wrongdoing to his supervisors of his chain of command, and almost immediately thereafter he was fired. Quoting from Irvin, the Irvin court said, if the plain meaning of this section leaves any doubt as to the inclusiveness of this right of action and the broad protections afforded, the legislature also provided. It is the intent of the legislature to prevent agencies from taking retaliatory action against any person who discloses information to an appropriate agency alleging improper use of government office or any other abuse on the part of an agency, public officer, or employee. The statute could not have been more broadly worded. However, this information got to the Inspector General's office, and the statute does not require a direct submission. It doesn't say direct. And in accordance with the mandate of Irvin and reading the statute broadly, this man, Mr. Crouch, was someone that the statute was intended to protect. Thank you.
Thank you.